Good morning. First, we must know how power of Patanis are being executed, whether there is any statutory provision to execute the power of Patani. Was there any court of records or a record to maintain the power of Patani records or not? Whether power of Patani must be registered or not? All these questions should be answered. In the year 1982, power of Patani has been executed. Power of Patani Act 1882 was enacted only for the purpose of, they say, the person who executes the power of Patani is called Doni. Must sign where sealing is required, must seal his principal name. The object of bill is to render it legal for such donis to execute with their own names, and the law respecting the execution of instrument and power will thus be made accordance with what will the rule in England. Then the act was amended 1882. They say, while suggesting that because of its archaic form and language it should be replaced by a new enactment. The act deals with the power, does not contain definition of power of attorney. It is proposed to remedy this defect by inserting suitable definition. The expression assurance being omitted unnecessary. Section 4 of the Act enables original instruments creating power to be deposited in a High Court, which without further would be sufficient evidence of the contents of the instrument, and they are deposited in the High Court. It is proposed to make this facility available even to persons who reside at distance from High Court. Accordingly, provision is being made for the deposit of these instruments not only in the High Court but also in the District Court. Section 5 at present worded gives impression that the marriage of the minor, which is prohibited by child marriage restraint, is permitted that a married woman who is a minor could execute power of attorney. Therefore, it is proposed to delete the reference to a married woman who is minor, so as to make it clear that minor, whether married or does not have power to appoint an agent or execute the power of attorney. So this act states that power of attorney must be registered with either with the High Court or District Court, and a separate file of instruments so deposited shall be kept, and any person may search that file and inspect every instrument to be so deposited, and a certified copy thereof shall be delivered out to him on request. So if this section 4 of the Power of Attorney Act is accepted, then at least it commands that the power of attorney should be registered. Therefore, this should be a compulsory registered document or deposited document with High Court or District Court. Otherwise, this is not valid. Then question arises, what is special power of attorney? No such special power of attorney. But however, Indian Stamp Act says power of attorney different kinds. When executed for sole purpose of procuring registration of one or more documents, then 5 rupees. When authorizing one per act in single charge other than the case mentioned, 15 rupees. When authorized more than 5 to act jointly and severally in more than one transaction, generally 100 rupees. When authorizing more than 5 but more than 10 persons, 175 rupees. When given for consideration, authorizing the attorney to sell inevitable property, the same duty as conveyance for the market value. Any other case for each person authorized, 20 rupees. So this is being termed as special power of attorney. Therefore, you all must understand what is power of attorney. And now I have a judgment. Now you can go through the judgment. AR 2022 Karnataka 155 GV Nagaratna and others, Lingam and others. This case says appointment of special power of attorney. There they have given certain guidelines. What all are the guidelines? attorney holder who has signed the plaint and instituted the suit but has no personal knowledge of the transaction can only give formal evidence. Then, if required, principal may be examined. Attorney holder cannot depose or give in place of his principal for the act done by the principal. When the principal at no point of time had personally handled or dealt with, participated in the transaction and no personal knowledge, and where entire has been handled by an attorney holder, necessarily attorney holder allowed give evidence. Where the entire transaction has been conducted through particular attorney holder, principal has to examine that particular attorney holder. Where different attorney holder had dealt with the matter at a different stage of time, evidence has to be laid as to what transpired. This is contemplated state of mind conduct. This is what they have given reasons. Given where the power of attorney can speak to what extent. You go through the judgment, and if anybody normally nowadays family court and even DVC cases, everybody started filing power of attorney. You can object to that by showing this act, whether that was registered or not. You can challenge it. I hope you understand what I want to convey. Best wishes.